This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviat. Tonight it's Ask Us Anything night. So call in your questions on everything from car accidents, medical malpractice. Have you been part of a motorcycle accident or have concerns about being involved in something? Products liability. Any kind of area that you've got questions about, call in the 31 Law Call number 256-536-0077. You can call in and ask your question live on the air. You can also text us to that same number and we will have your text coming up live. You can also email us a question any day of the week on any legal topic. You send it to lawcall@waaytv.com, and when we get to a show that's on point, we pull some out. We've got some of your email questions coming up tonight. Will League is here from Timberlake, League and Brooks. They do all kinds of personal injury cases, right?
That's right, Sharon.
So what does that include?
You know, mostly, personal injury, whether it be car wrecks, medical malpractice, workers' compensation, premises liability. And, people, when your ox is in a ditch and you need help, you got medical bills, what do you do? What's the process? Labor Day's coming up, and with this summer we've seen the uptick in boating wrecks.
Yeah.
And in school bus situations, a young man was killed on a bicycle. And everybody's going back to school. What issues are there? There's school immunity. We've got some assault cases that we're working on in terms of, what are the repercussions? Now, usually you have, there's discretion, and so your teachers are going to have immunity for most types of conduct. But with regard to the bus wreck cases, if you remember years and years ago, I worked on the Lee High School bus wreck cases.
Terrible.
And we're seeing more. We've seen some drivers that in DUI, it's 0.08 BAC or blood alcohol content. For a bus driver, it's 0.04. Okay. And so unfortunately, we've seen the news that North Alabama bus driver was taken in for over the legal limit. And so that big range. Okay. That big range. And you do a lot of domestic stuff. So where our worlds collide is if let's say I have a client who is in the process of a divorce, and we recover. We either win at trial or we recover, or there's a settlement with the insurance carrier. Oftentimes I will get a DHR notice if there's back child support. Yeah. You're doing that case. Yeah. And so we have to, given that we are served with a lien, we'll have to come in and actually pay that before I can disperse funds to my client. It may be a chance for somebody to get paid where they've been owed for years and years and years. Or you have a case where the parties might be divorcing or divorcing in the future and a spouse wants a portion of that. Can they get it? So sometimes they can. Sometimes they can get something. So call in or text in your questions tonight, 536-0077. We'd like to get you started with some video. Okay, this is a machine like you've never seen before. This is a popcorn maker. Have you ever seen anything like this? Of course, it does not go as planned because that wouldn't make it to our videos tonight. And I don't know what he's doing to it. Look at that. Fortunately, it looks like nobody is seriously hurt. I don't know what kind of popcorn machine this would be. But it brings us to product liability questions. So if something has gone wrong with this machine and he's operating it correctly, what do you see when you look at something like this? It looks like it's a homemade situation. And so there's a couple things that come to mind, but let's assume that's in the States. It looks like it's abroad. It does. Wow. And so, all right, products liability. Alabama Extended Manufacturer's Liability Doctrine basically states that if you design, manufacture, or place a dangerous or unreasonable dangerous product in the stream of commerce, you could be liable. Now, that product must be used for its intended purpose and cannot be altered. And so in this particular case, I'm not certain that was manufactured. It looked like a homemade jet engine
it looked like something
situation.
Put together.
And so, all right, first off, he made it himself. He brings it in the public, and he blows it up. He could be liable for property damage, injuries for anybody around. The manufacturer of that item could be liable if, again, that product was used for its intended purpose. And the example we use is if you can't use your weed eater to trim your beard. And so if that was not what its intended purpose, the manufacturer will not have any liability unless it could have been, designed safer. It was easily discoverable. There was other alternatives, and it was cost effective to do so. So we're not going to make people go around the world, or manufacturers go around the world, but if it's a reasonable solution that is the industry standard, then products liability, could be the claim.
We've got callers on the line. We've got Mark on the line with a question from Gadsden. Hi, Mark. Thanks for calling. What's your question tonight?
Yeah. Hey, thank you for taking my call.
Sure.
And I don't know if I should try to stick with like the a very short version, or how thorough I should explain my situation. But again, I really appreciate you guys taking my call, because I'm almost at my wit's end here.
Well, tell us what's happening in brief, but then we'll ask follow-up questions to see if we can get to the bottom of it.
Yeah. And let me preface this by saying that the conclusion I came to is that I think probably the best legal theory on which to approach this would be a breach of contract theory. One of the problems I've encountered, although like no attorney has sat down and evaluated my case, almost invariably I'm being told that, well, we don't handle cases like that. A couple years ago, this is going back to 2022 now, I took out a mortgage to purchase a property, and it's a manufactured home on land. And prior to closing, I even had a conversation with my loan officer and explained that if the house had been moved, like from one location, had, say, been sited in one place and moved to another, it would be ineligible for the loan, for financing, because it was a conventional loan that was sold to Fannie Mae. And for that matter, any type of insurable mortgage, FHA, USDA, VA, you name it, if a manufactured home was moved from other than the dealer or the manufacturer on what they call it second set, would be ineligible.
Okay.
Be ineligible for the warranty or for the mortgage?
For the purchase mortgage.
Okay.
And then after I closed, I was looking at some of the documentation again. And like I was looking at the appraisal that the lender used. The appraiser appraised the house as in 1999, I noticed. But then I was looking at the warranty deed. It was handed to me like after closing. And it took me several months after closing to mentally process the significance of this. But it explicitly says right on the warranty deed that it's a 1989 house with the serial number of the house. But the oldest deed entry was from the beginning of 1999. I'm like, well, that's kind of weird.
Yeah.
See, I moved from Georgia. I'm not from this area when I bought this property. And I learned that this used to be part of farmland. It was parceled out in the 1990s. The property first went on the tax rolls in 1999. In fact, this road that the house is on, I pulled up an archive map put out by the Alabama Department of Transportation. This road didn't even yet exist in 1995.
Gotcha.
So you can prove that's a newer home and not 89. Did the bank end up pulling your financing? What was the result?
Well, no. Well, I did confirm it was sitting elsewhere from 89 to 99.
Okay. So it's been moved, and now you figured it out. Are they trying to cancel your loan, or are you just worried what to do?
That's not so much the problem, but what I realized is that the property was undoubtedly ineligible for the mortgage that was consummated. My argument is that I never would have entered into a mortgage contract on an ineligible property, that the consummation of the mortgage ipso facto implied the property is eligible for the mortgage. Because the problem I'm facing now is when I sell it, I can't sell it to somebody else the same way it's sold to me, that it's probably going to have to go cash. And I'm trying to understand, how the lender up to this point, who's now the servicer, that they basically done nothing but gaslight me.
Right. Let me ask you this, Mark. When you purchased the property and you've got your sales contract, was it advertised to you as an 89 home, or was it a 99 home?
Well, that's interesting. It was actually listed in the MLS as a 99. Like I said, the appraiser appraised it as a 99. So it looks like somewhere in the transaction that they conflated, somebody conflated the year of the house with the year of the property itself. which of course caused that decade of house history.
Yeah, and the question is, Mark, who is that somebody? So if if the seller advertised that home to you and sold that home to you as a 99 and it happened to be an 89, that's a material breach. I agree with you. It could be a breach of contract action. So again, you know, if you have a material breach, one of the main elements of the contract, and that's a big deal, a 99 home versus an 89 home that takes it out of any warranty, and that is substantial. All right, so you have a breach of contract claim against the seller, potentially the appraiser. If the appraiser, and you may have insurance for this, but let's say that whether there's appraisal or investigation done by the bank, if it was done so in a negligent way and failed to discover that it was an 89 home and not a 99 home, which thereby negates any warranty and any secondary issues that you may have a claim against the seller and either the appraiser or the investigator for the bank. Now, that is a breach of contract claim, and you have 6 years under Alabama law to make that claim. And so, but I would recommend going and sit down with an attorney, because again, let's say you bought it for $100,000 and you have to sell it for $50,000. You've got a substantial damage that you entered a contract. It was a bona fide issue. It was a material issue with the contract, and I think that's actionable. Now, would have due diligence, their defense might be, should you have discovered that in your view of the documents? Is it in the four corners of that particular sales document, or is it readily available with the supporting documents that are attached to that? So you may have a defense from them with regard to what you should have done, or how you should have mitigated your damage, or you should have known. Was it as is? You know, some cars that you purchase, it's as is, and that's it.
Yeah.
Is there a warranty? But did they misrepresent a material fact that caused him to enter in this contract to his detriment? And that would be the element. So I agree with you, Mark. I think it's a breach of contract claim. And
what kind of lawyer is he looking for to take on something like this?
Litigation real estate lawyer. Okay. And there's some good ones in North Alabama.
Okay.
And depending on the delta of the difference between the value of the home now versus what he paid for it. Now, sometimes if it's not much, a lot of lawyers charge by the hour.
Okay.
It could be $200, $300, $400 an hour, and all of a sudden he's upside down.
Right.
And so he has to make
if it's only fighting over $10,000, may not be worth it.
Exactly. So he has to make an educated decision as to whether or not the benefit outweighs the risk of the attorney's fees. Now, you know, firms like us, we charge a contingency fee, which is whatever a percentage of what we recover. But often transactional lawyers will be on an hourly basis, and then Mark has to make a determination whether or not it's worth the legal fees to go after. What are you going after? And you want to know that up front before all of a sudden you're upside down. You spend X amount, and you spent more on attorneys than you would have, what your damages would be.
Okay. We're going to take a break. We'll be right back. We've got folks on the line. Stay on the line. We'll be right back answering. It's Ask Us Anything night, so we will have that right ahead.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Maservi, and hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. It's Ask Us Anything night. Will League is here from Timberlake, League & Brooks, and they got a big honor. Timberlake, League & Brooks has been honored in the brand new edition of Best Lawyers in America. Michael, Will, Heath, and William all receiving recognition, and Bobby Marsh listed as one to watch. Congratulations. That's good looking.
You know, thanks. Bit of a humble brag, but you know, we've got great staff and great returning clients, you know, and we advertise, but most of our business comes from word of mouth and repeat customers or referral for people that we have. And we have a wonderful staff, an office manager, and all the paralegals and secretaries and runners. It takes a village.
It does.
It really does. And thank you, everybody. And
that's great.
We're just very grateful to be in that company. We sure are.
Very nice. We've got callers on the line. Diane, thank you for waiting, from Hazel Green. Hi, Diane. Thanks for calling. What's your question tonight?
My question is, being an only child, do I need to have power of attorney?
For your parents, is that what you're talking about?
Yes.
I think she needs to have those documentations. What kind of basic estate planning documents would you recommend everybody have?
When it comes into our particular world, in the personal injury world, God forbid someone's incapacitated, and who has the ability to make the decisions for them? Got several cases, well, got a case right now. The plaintiff is incapacitated. There are no documents, and so who is to make decisions, not only legal and medical? And so we recommend, I get it, a lot of folks don't have wills until they're getting on a plane and things like that, or their kids need something. But we ask folks, make sure you've got a will, and you've got a personal representative that can make decisions for you if you were to perish, an advanced health directive to where, God forbid, you're incapacitated and unable to make those, and then a power of attorney, and that person can do anything that you could do that, that you could make your decisions. You're unable to make those decisions. That person, you want to make sure he or she is trusted and capable and all those things. But those are the three things that we recommend. So is it vital? Depends. If God forbid, one of your parents can't make the decisions and you have to go in and help, then there's more legal hoops for you to go through to get access to whatever information you may need to help your parents. So depending on their age, but those three things are pretty much staples in estate planning. And I'm not talking about the Rockefellers, but we're all gonna get sick. We're all gonna have issues there. So it's only a matter of time. And so to have a healthcare directive and a will is just, it's prudent and it's smart. You'd rather have it and not need it.
Just because you're an only child doesn't mean the doctors or the medical staff are going to know that you're an only child, or that the bank is going to know that you're the person who eventually would get something, right?
Right.
You need to have those records in place now for when something actually does happen, and you need to step in and you need to be recognized to do the things that need doing.
That's right.
We've got, is it Larry on the line? Larry from Tennessee. Hi, Larry. Thanks for calling. What's your question tonight?
Thank you. I'm a landlord, and I've got a rental property that they put a above-ground pool in, and it's about 3 foot deep, about 15-foot size. And the reason for it, they've got a child about 8 or 9 years old, something like that has MS, and they using that for therapy plus recreation as well. And my question is there any kind of legal document or anything like that I can get to where I would not be liable for any accident or death at that because of the pool?
Yeah,
Right.
It's something to worry about, isn't it?
As the property owner, you could have an indemnification agreement with your tenants and require them to have insurance for that particular pool. Now, again, if you're on notice of a hazardous condition, let's say that the restrictive covenants or local law says, you know what, you got to have a fence around this pool. And I've unfortunately had several death cases where there's no fence, child wanders in that area and drowns. And let's say you as landlord knew that it was in violation of either code, restrictive covenant, local laws, and you allowed that to go on. You could be liable as the property owner. Now, to remedy that, you can enter in a contract, indemnification situation where it says, look, tenants, if you guys are sued for anything regarding this particular pool, you indemnify me. And if there's a judgment against me, you as the tenant will indemnify me. And that paper may not be worth anything if there's no assets to back it up. So God forbid, let's say the worst happens. A neighbor's child comes over and it's in violation of the code and they perish. You could be liable, the renter could be liable, and if there's no insurance, renter's insurance to cover that, indemnification doesn't really help you if the renters have nothing to satisfy that judgment and indemnify you. So not only do you need that agreement, but you need to mandate some type of insurance to go along with that so you are protected. And that's, that would be the way to address it. And again, remember that you may want to, in any agreement, make sure that all laws are complied with, restrictive covenants and the like.
And I bet he's trying to be cooperative with the family that's got that child with MS. But you want to protect yourself too.
But bad things can happen, and if it's not out, get a fence around it and just make sure. But get those protections in place.
So we got a text in from Shelley. Shelley's dealing with a situation where she hired a mosquito control company last year, and she paid them for what the services they did last year. But she told them, "I don't want it anymore." She told them.
Right.
And yet they keep coming.
So she said she called them before they came.
Yes.
They came 4 times.
Said,
she
don't
put them
want
on
any
notice.
more. And now they're still coming, and they're also still billing her.
You know, a couple of things. Number one, she told them not to come. She did hire them for last year, and then they came this year. Now, she did receive the benefit, but she did not want that particular service. So, you know, at the initial outset, her argument would be, I did not contract for this particular service, therefore I'm not responsible for payment. Now, let's say she was sued by the mosquito company. She got the benefit of that. Don't think they would win, but it would be an argument for the company to say, look, we provided you with a service and you can't get that for free. Now, her response is going to be, there is no contract. So it could be a fuss, but in the end, I think the law would go with her because she didn't contract for that particular service. So you may want to send them a letter, you know, so you have that documented, just in case they turn you over to collections and you got to go that route. But, you know, provide them written notice in addition to just calling them.
Okay, we got this text from Tony. Tony called an eyeglass company. They said they were in his job's insurance group, so he ordered glasses from there, goes to pick up the glasses, and they say, oops, no, your insurance doesn't cover us. What do you do? He had to pay full price for the glasses.
You know, if they provided him notice before he paid for those glasses, even though they were mistaken, it turns out if insurance doesn't cover it, and he's aware of that before he provided money, then he had already entered into that contract. He could not go back and then say, you know what, I get these glasses for free. He either returns their glasses or pays for them, as long as they provide him with ample notice that it's not covered. And even though they made a mistake and it was a pretty big head fake, he probably wouldn't have ordered those glasses. But if he's got the glasses and they're not covered and he pays for them, that's probably where it's going to land.
Okay, we're going to take a break. Be right back. It's Ask Us Anything night. Stay with us. If you haven't gotten your questions answered tonight, here's how to get in touch with Will Lee with Timberlake, Lee & Brooks in Huntsville, 256-536-0770 or 800-804-2502. The website is law-injury.com, and if you like them on Facebook, you can learn more about the law that way.
And our very own Sharon Dovey at 539-7337, SharonFamilyLaw.com, child support, divorce, all the things.
All that happy stuff. We got an email question from Mark. My teenager gets his license next week, and we're trying to prepare for any kind of situation. He asked us the other day, if I get in an accident, what do I do? What do we tell him?
Right.
Don't get in an accident.
Yeah, man, I hear you. I got 4 kids, 3 of them driving. Number one, hey, teach them how to change a tire. Let's not have anybody stranded out there. I tell mine, get out of the road. If you're in a wreck, let's not have a second impact because we're there looking around. We've got a death case. Somebody was conked out on the road, got out of the car, stayed with their car. It was hit. Get out of the road. Safety first. If you have time, if nobody's injured, you can get pictures of the photographs of the scene. It's kind of like a gun. You'd rather have it and not need it than need it and not have it. Get it if you get any witnesses. But get out of the road. Safety first. And we'll deal with everything else later, but let's not have a second accident.
Thanks for all your questions. We'll see you next week.